I got to tell you, I'm excited. Everybody's afraid of legal issues, but this is my most favorite part. This is my most favorite lecture because the law is so cool, right? Law is fun. I love the law. I would marry the law if I were allowed to, but they won't let me. My husband wouldn't like it either. So I can't marry the law, but I would like to share the law with you, okay? Now, we can do this the hard way or the fun way. Fun, yeah, fun. We'll do it the fun way. There is no easy way because law isn't easy. I'm sorry. I wish I could help you with that. I did, however, put a study sheet in your handout material. I would use that, especially for the final exam. This is called a clue. This is called a clue in criminal justice. So use it for the exam. But yeah, it's important stuff. So what I'm going to do is give you a little background first, and then we're going to walk through the amendments one by one, the ones that apply to corrections, okay? We'll leave all the rest of them out. We don't need to look at the Third Amendment, quartering of soldiers, or any of that stuff. So just the ones that apply. And I don't know, I think I've got some pretty good stories that should make the points for you. Okay? We're ready? Are you excited? I am. So let's begin with the development of inmate legal rights. They actually had to develop, we didn't just have them. The development of inmate legal rights, beginning with the hands-off era. Remember that from your reading? So what is hands-off? We actually talked about this way back at the beginning of the semester too. What is hands-off? What does that refer to? Period of time roughly between 1866 and 1963.
Where the courts interfered or intervened with the corrections institutions. So
well,
they...
Hands off.
Oh, yeah, so they didn't.
So all right, Corey says where the courts refused to intervene in corrections issues and how our prisons and jails were run pretty much at a nationwide level. And that is correct. The courts refused to deal with anything related to corrections. They kept their hands off. Now, they had a few good reasons for this. Well, maybe not good. They had some reasons for this, okay? You can decide if they're good or not. But basically, the courts are refusing to accept lawsuits of any kind regarding the violation of inmates' constitutional rights, which were pretty prolific in this period of time. Inmates were treated pretty poorly. Now, reason number one, they said that they should keep their hands off. It's not a bad reason, I suppose, but the court said, well, you know, hey, we don't really have any experience in corrections. We really don't know anything about running a correctional facility, prisons, jails, and such like. So, you know, we're just going to keep our hands off of your business and leave that to the prison administrators and jail administrators. You guys run your business. All right, maybe. The next one I think might be a little lame. Well, we need to separate the powers between judicial, executive, and legislative. Right? Separation of powers. And of course, law enforcement falls under the executive branch, and the courts are the judicial branch. But I don't know. Are you buying that one? Not so much. Finally, one that makes sense. That accepting one lawsuit would inevitably lead to a flood of prisoner lawsuits. And guess what happened? Once the handoff era ended, it led to a flood of prisoner lawsuits. So this was pretty legit. We're opening up Pandora's box, if you will, big can of worms. And that was legit. So that's one of the reasons they didn't want to go there. The hands-off era was supported in case law. Our first case is Ruffin versus the Commonwealth of Virginia in 1871. And what this did was declared that inmates were slaves of the state with no rights. Now I want you to take a look at that date, 1871. The Civil War ended in 1865, and the slaves were all freed. And the South is just totally trashed after the war, and there is nobody to clear land, build roads, clean up the mess, put in the crops, harvest the crops, right? No more slaves. So what did we do? We backdoored it. We snuck in the back door. We said, hey, you know what? We could just declare prisoners slaves of the state, and then we've got our free labor force again. So They backdoored it in a really sneaky, awful way too. They passed these laws called Jim Crow laws that essentially only applied to the newly freed slaves, causing them to run afoul of the law and get arrested and become prisoners. And now, slaves of the state. And prisoners in this time were worked in just absolutely horrendous conditions and kept in conditions far worse than in slavery. Isn't that a sneaky lowlife thing to do? And we did that. Price versus Johnston, 1948. So we're going to fast forward, and we're going to modify this whole slaves of the state idea a little bit. And instead of saying slaves of the state, we're saying, well, all right, maybe not slaves of the state, but you know, prisoners really must expect to lose some rights as part of their punishment. It's a collateral issue attached to their punishment. Well, that's a little more reasonable, would you agree? Now, you don't have to write this red stuff down, but here's what was going on in this period of time. There was little control imposed over the day-to-day operations of correctional facilities. They were run however, pretty much the warden or whoever saw fit. They were very poor conditions of confinement. And many of the facilities were in a state of physical deterioration and nobody cared. Lack of public attention, out of sight, out of mind. Who cares? They're just convicts anyway. Add to that low staff salaries and poor training due to the low funding priority of correctional facilities. Remember how we talked at the beginning of the semester and said that corrections and corrections officers are kind of like, you know, the nation's trash collectors? We referred to corrections and corrections officers as the nation's trash collectors. And that's reflected here. We're not going to pay them very well, so that means we're not going to be able to recruit really good people. We're not going to train them because nobody wants to spend money on trash, right, on convicts. In fact, in the mid-1960s, which really, folks, isn't that awfully long ago? About 40% of our nation's correctional officers didn't even have a high school diploma. They lack education, they lack training, we're not paying them very well, so you can kind of see how this sets the stage for abuse and mistreatment. And add to that the fact that wardens didn't come up through the ranks. They didn't know the job, they didn't know what it was like dealing with prisoners, they didn't know the first thing about corrections. It was a political position. They were appointed based on politics, not experience. See the problems. The prisoners' rights era, we're going to kind of tag this in the vicinity of around 1964 to about 1978-ish. Depends on whose book you read, I guess. That's probably right, though. Prisoners' rights era. So we end hands off. Cooper versus Pate, 1964, was the case law where the court ended the hands-off doctrine. They said, well, we kept our hands off of your business for quite some time here, and you've showed us over the course of time that this was a bad decision. That we very much need to have our hands on your business because you can't seem to run things correctly. So what this basically did, this case law Cooper versus Pate, said that now inmates can challenge violations of constitutional rights. And the floodgates opened. We saw a lot of challenges. Case law after case law after case law after case law came down challenging conditions of confinement, inhumane conditions, constitutional rights violations, all in an effort to correct all of the bad that was going on. So I'm going to refer you to Section 1983 of the Civil Rights Act, which basically says no government representative, it means police, corrections, any aspect of the government, may deprive constitutional rights under color of law. In other words, hiding behind the law. So there you go, includes police and corrections officers. Deference, what is called the deference period. So, you know, more or less begins around 1979 and, you know, they say to present. Now, deference is the period we enter where we go from really very few prisoners' rights to an abundance of prisoners' rights. We've had all these case laws come down, and we just went kind of crazy with it, and we actually kind of went too far the other way. So much so that prisoners were actually able to get away with an awful lot of stuff that they shouldn't be doing in correctional facilities. So once we realized what had happened, we sought to center that up, to bring it back in the center so that, yes, prisoners do have rights, but we also have to take into account the needs of the facility and security. So the deference period, most would agree, began with the case law in 1979, Bell versus Wolfish, which said a lot of stuff. I'm not going to get into it too heavy here. Anybody had legal issues in corrections yet? Yeah, they'll hit that one hard. And the deference period restored the balance between prisoners' rights and institutional needs. Now, inmates have all rights that are possible under conditions of confinement. So we'll give them as much as we possibly can, being mindful of the needs of the institution. We use what is called a balancing test. Prisoners' rights versus the needs of the institution. This is referred to as the Turner test, coming from the case law of Turner versus Safely, 1987, where the court said, we may only restrict prisoners' rights if there is a legitimate penological interest. Legitimate penological interest. If there is a legitimate penological interest, then we may restrict prisoners' rights. What do we mean by that phrase, legitimate penological interest? You know what interest is, right? Something that concerns or interests. What's legitimate mean? Real, yeah, real, actual. And penological, pertaining to punishment or the prison. So a real or actual need or interest of the facility, not something that we just made up. So, institutional order would be one of those. Security would be one of those. Safety would be one of those for both inmates and officers. And finally, rehabilitative efforts. Those four items have been defined as being very significant, legitimate penological interests. So we will allow inmates to have all rights possible until they bump up against any of those legitimate penological interests. Does that make sense so far? Mm-hmm. So balancing test, right? Now you don't have to write the red stuff down because we're going to talk about it one at a time. Inmates' rights include religious freedom, freedom of speech, which refers not just to the spoken word, but to all communication, access to the press, search and seizure, medical care, privacy, access to the courts, conditions of confinement, and discipline.